Justice is supposed to bring answers, but lately all we are getting is uncertainty. Andrew Malkinson has finally won his compensation claim, but how much will he actually get? More than a year and a half after his conviction was overturned, no one knows yet. Meanwhile, Victor Nealon, in an almost identical case, was denied compensation entirely. Why? No clear explanation. The Thirlwall inquiry isn't just facing doubts. Its usefulness and effectiveness are now under fire. Critics warned it was rushed, premature, and too limited in scope. Now those warnings are becoming reality in light of the findings of an international panel that have cast serious doubt on the Letby conviction. These findings have prompted Letby's lawyer to file an application to the CCRC. But with the CCRC still leaderless a month after Helen Pitcher resigned, what can we expect from them, especially with the Letby case hanging in the balance? And Peter Sullivan, new DNA evidence has been found, but it doesn't match him or anyone in the database. And yet there is no appeal date. It feels like the justice system is stuck in a limbo. So what's going on? Let's break it down. Welcome to Spoken Injustice, where we put the criminal justice system in the dock. We have worked hard to bring you another packed news session, and today the theme is uncertainty. Before we jump in, make sure to hit the subscribe button to help us bring together news stories that are often presented in isolation by mainstream media. We connect the missing dots to give you the full picture. Let's start with some good news for once. It's been revealed that Mr. Malkinson has won his statutory compensation claim. Our heartfelt congratulations go to him. And we hope this can contribute, at least in some way, to his long road to recovery, though whether he will ever fully recover remain uncertain, and we have our doubts. But is this really good news? Compensating a man who was wrongfully imprisoned for 17 years of his life for a crime he didn't commit, essentially robbing him of his prime years when he could have built a career and a family, is the bare minimum the state can do. Yet despite this, we are left with more questions than answers. First, why has it taken a year and a half for this partial decision? While we are told that he won the claim, he's only been given an interim amount, and the final figure still hasn't been determined. The answer may lie within the compensation scheme itself. Section 133A of the Criminal Justice Act 1988, titled Miscarriages of Justice Amount of Compensation, states that when assessing compensation, the assessor must consider, among other things, the conduct of the investigation and prosecution of the offence. As we know, there is a pending inquiry into the very conduct of Andrew Malkinson's investigation and prosecution. In light of this, it seems that at this stage, pending the inquiry, a full assessment may be impossible. But that brings up another question. Why hasn't the inquiry, which began a year ago, progressed beyond Phase 2? Phase 2 was launched on the 24th of February 2024 and includes continue to seek and receive disclosure from material providers, reviewing the forensic actions and decisions, this work being conducted by an independent forensic expert appointed by the inquiry, identifying and requesting witnesses to provide statements on relevant issues, determining the scope of the inquiry's next phases. How long can all of this take? The only certainty we have, though, is that the total amount of compensation will not exceed 1 million. In fact, Section 133A states at subsection 5 that the total amount of compensation payable is 1 million in a case to which Section 133B applies. Section 133B applies to those who have been detained for at least 10 years. As we know, Mr. Malkinson was detained for 17 years. Toby Wilton, an associate of Hickman and Rose, who have represented Mr. Malkinson in his compensation claim, says it is not right that the statutory compensation scheme can only pay out a maximum of 1 million to victims of serious miscarriages of justice. He points out that this limit was set nearly 20 years ago in 2008, and factoring in inflation, the 1 million limit will be equivalent today to 2 million. It is clear we will have to wait a while before we will be told exactly how much Andy Malkinson's torture is worth in the eyes of the state. But perhaps the most troubling uncertainty this news brings is the contrasting compensation outcomes in two strikingly similar cases. We have repeatedly highlighted the stark and unsettling similarities between Andrew Malkinson's case and that of Victor Nealon. Both men were wrongfully convicted and spent 17 years behind bars for crimes they did not commit. Victor Nealon, originally from Dublin, was convicted in 1997 for attempted rape. His conviction was overturned in 2012 after DNA testing of the victim's clothes revealed the DNA of an unknown male. Despite this, Nealon was denied the compensation in 2019. The only apparent difference between the two cases is that the DNA found in Mr. Malkinson's case led to a match in the database, where no such match has been found in Nealon's case. It's deeply troubling and frankly absurd to think that a man should be denied compensation simply because the true perpetrator hasn't been identified, especially when this lack of identification is beyond his control. This raises serious questions about how these decisions are made, highlighting the arbitrariness and uncertainty that surrounds crucial determinations such as this. Mr. Nealon was represented by a determined advocate, Mark Newby, who fought tirelessly on his behalf, even taking the case to the European Court of Human Rights. We have discussed this in a previous video, which you can find linked in the description below. Mark Newby told us, "You are right to raise a question about Victor Nealon. I can simply say the issue, which is complex, is on our radar, and we will say more next week on behalf of Victor Nealon." We look forward to hearing more, and we will keep you updated. Meanwhile, as we have reported in great detail in our video last week, a panel of independent and eminent neonatologists and other pediatric specialists have released a report which casts serious doubt on the Lucy Letby conviction. Where does this leave the Thirlwall inquiry? As we know, the inquiry into Lucy Letby's actions at the Countess of Chester Hospital commenced on the 10th of September 2024. The evidence phase started on the 16th of September 2024 and concluded on the 17th of January 2025. In her closing remarks, remarks, Lady Justice Thirlwall summarised the key statistics, stating that 133 witnesses have provided live testimony and 396 witness statements were submitted. What she did not mention is that the inquiry is predicted to cost nearly 20 million in public money, as the Guardian's Today in Focus podcast has revealed. We will hear an excerpt of the podcast shortly. The next phase of the inquiry involves the submission of written closing statements by core participants, which are due to be received by the inquiry by the 28th of February 2025, and oral submissions will be heard on the 17th and 18th of March 2025. The inquiry's primary terms of reference included investigating the conduct of hospital staff, including the board, managers, doctors, nurses, and midwives, in relation to Letby's actions during her employment as a neonatal nurse and beyond. The systems and procedures in place for safeguarding infants in neonatal care. From the outset, the remit of the inquiry was limited, as it proceeded in the assumption that Lucy Letby was guilty. On the 10th of September 2024, at the opening day of the inquiry, Rachel Langdale KC, counsel to the inquiry, stated the inquiry's unwavering focus will not be examining the convictions, but rather what the response of those at the time was and should have been to what they knew or should have known at that time. Doctors, managers, and the board were presented with a developing situation which called for a careful and thoughtful response. We will be investigating how individuals went about this task and whether their thought process had at the forefront the need to keep babies safe. By taking this approach, your inquiry, my lady, will serve the vital purpose of keeping babies safe in the future from those rare cases when a healthcare professional intends them harm. From the beginning, we have been high critical of the inquiry, raising concerns about its fairness and effectiveness. The way it is framed inherently suggests wrongdoing, which undermines the inquiry's ability to uncover the objective truth. If, as a distinguished international panel now strongly argues, no actual harm was done, then the very foundation of the inquiry is called into question, as is based on a premise that obstructs a fair and impartial reassessment of the facts. Felicity Lawrence, a respected investigative journalist for The Guardian, aptly likened the inquiry to Alice through the looking glass. Let's listen to her perspective on this matter.
And there is also, since her conviction's been the Thirlwall inquiry, a public inquiry which is looking at the circumstances at the Countess of Chester Hospital when Letby was said to be killing and harming these babies. It's projected to cost nearly £20 million in public money. They've finished hearing evidence, but it's yet to report back. Was there anything that came out in that inquiry which the jury hadn't heard and which you think adds credence to the idea that Letby may be innocent?
The inquiry feels like Alice through the looking glass, because it only can proceed on the basis that she's guilty, despite these huge doubts. And they keep publishing information that we haven't had before that really does add to the experts who are saying this is not safe conviction. The case where Dewey Evans thought he could see in 10 minutes that there'd been foul play with two babies who had liver injury. The parents, for the first time, have described the very traumatic nature of the birth. And that wasn't considered at trial. And the experts very quickly said that's most likely to be a liver injury, which is birth trauma, And then there was other evidence that a needle inserted by the doctor had also lacerated the liver. So yes, we are hearing things, but the bizarre point is that the Thirlwall inquiry is deaf to it.
It's difficult though, isn't it, when she has been convicted and she's been refused leave to appeal twice? How could they proceed otherwise?
Yes, I think I question the timing of it. It was set up before the appeal process has been exhausted with this very narrow remit that she's guilty. And there have been other cases, say with Hillsborough, where people had, verdicts had been reached, but the inquiry chose to make it a much more open inquiry that did allow some doubts to be expressed about all that. But ministers have set it very narrowly, and I think probably dived in too early. And so it's a very unenviable position for the judge who's chairing it to be in.
Numerous calls to postpone the inquiry or change the terms of reference were made just before the inquiry started. You may recall an article from The Guardian last August where it was reported that a group, including some of the UK's leading neonatal experts and professors of statistics, is calling on the government to postpone or change the terms of a public inquiry over concerns about the conviction of the neonatal nurse Lucy Letby. As we know, those warnings were disregarded, and the inquiry proceeded nonetheless. On the 8th of February 2025, following the press release in which the international panel revealed its findings of no murder, the Telegraph reported that Lucy Letby's barrister called on Wes Streeting, the health secretary, to halt the Thirlwall inquiry. The barrister argued that the inquiry was operating on a false premise by assuming Letby's guilt rather than reassessing the evidence objectively. The Thirlwall inquiry remains a subject of intense debate. Concerns over its assumptions, timing, and medical evidence continue to fuel calls for a more objective reassessment of the case. As the closing submissions approach, scrutiny of its fairness and credibility is likely to increase further. And regarding Lucy Letby, how confident can we be that the CCRC is equipped to handle the immense pressure of a case that has faced widespread criticism and numerous twists and turns? As of today, the CCRC is still in the process of appointing a new chair following the resignation of Helen Pitcher on the 14th of January 2025. We discussed the circumstances of her resignation in our last month news session. The Ministry of Justice has indicated that an interim chair will be appointed as swiftly as possible. This much is confirmed in the CCRC latest board meetings notes of the 17th of January 2025. Under paragraph 4, arrangement for an interim chair, states that the chief executive provided an update from David West at the Ministry of Justice regarding the appointment of an interim chair. That person will need to have a royal warrant because the chair of the CCRC also needed to be a commissioner. David West would keep the chief executive updated. The notes suggest there is nothing to worry about. The CEO highlighted current business as usual, with the Northern Ireland visit still going ahead next week and a referral having been made today. And to be fair to them, there have been 5 referrals since the board meetings. In the meantime, the Justice Committee has formally requested that the role of the CCRC chair be subject to pre-appointment scrutiny, emphasising the need to restore public trust in the organisation. However, will this actually make a difference? First, while select committee pre-appointment hearings serve serve various purposes, such as scrutinising ministerial decision-making, providing public reassurance, demonstrating the candidate's independence of mind, and enhancing the legitimacy of the appointee. The committee's observations are not binding. As a result, the hearing could ultimately prove to be a meaningless exercise. Secondly, can we actually trust the committee's judgment? When Helen Pitcher was appointed chair of the CCRC in 2018, no pre-appointment hearing took place. However, in 2023, the Justice Select Committee assessed and endorsed Pitcher's suitability when she was appointed as chair of the Judicial Appointment Commission, the JAC, which is the independent body responsible for judicial appointment in England and Wales. At the time, the Select Committee faced criticism for failing to identify a clear potential conflict of interest between her role as JAC chair and her position as a chair of the CCRC. In an article published at the time, Hannah Quirk and John Robbins, both with long-standing professional and academic interests in miscarriages of justice and the CCRC's work, highlighted this issue. They pointed out that the JAC role required building a constructive relationship with the judiciary, whereas the CCRC's purpose is to refer cases where judicial errors may have occurred, potentially inviting criticism from the courts for referring controversial or borderline decisions. On the 7th of February 2025, Sarah Sackman, KC, MP, wrote to the Select Committee on behalf of the Lord Chancellor. Given the need to stabilise the organisation, the Lord Chancellor will appoint an interim chair at pace to lead the CCRC. This person will be tasked with undertaking a review of how the organisation operates. Additionally, the Law Commission are currently undertaking a review of the laws surrounding appeals for criminal cases. This department will consider findings of that review alongside the findings of the Henley report to ensure the appeal process, including the role of the CCRC, is fit for purpose. As of today, as far as I know, there has not been an official announcement regarding the appointment of an interim chair. Finally, I chose to end with a completely unrelated case, though the underlying thread remains, as this too is a case tied to the theme of uncertainty and limbo, the case of Peter Sullivan, which we first presented in our video, The Art of Forensic, 5 cases where science failed justice, linked in the description below. To briefly recap, in 1986, 29-year-old Peter Sullivan was arrested and later convicted of murdering 21-year-old Diane Sindel, a florist from Seacombe, Merseyside. To save for her upcoming wedding, Diane also worked part-time as a bartender in a pub in Bebington, about 5 miles from home. On the 1st of August 1986, after finishing her shift at the pub, she got into her van to drive home, but it ran out of petrol shortly after, forcing her to continue on foot. However, she never made it home. The next day, a local dog walker discovered her body. Peter Sullivan was accused of sexually assaulting and murdering Diane Sindel, allegedly using a crowbar and leaving bite marks on her body, evidence that played a key role in his trial and earned him the nickname of the Wolfman. He was not considered a suspect until weeks after the crime, following a nationally televised Crime Watch reconstruction, the one we saw earlier on. On the night of the murder, Sullivan was said to have been drinking heavily after losing a darts game. Upon his arrest, Sullivan initially confessed, claiming that he had stopped Miss Sindel to ask her the time, when he was then seized by a sudden desire to kill. However, he soon retracted his confession. According to a Daily Mail article from the 2nd of February 2025, Sullivan later wrote a long statement expressing confusion over his own false admissions, saying to the police he felt daft and couldn't understand why he kept lying. Sullivan did not initially appeal his conviction, but applied to the CCRC in 2008, requesting a review of potential DNA evidence. However, the FSS advised that further testing was unlikely to produce results, leading the CCRC to reject his application. In 2019, he sought permission to appeal directly to the Court of Appeal, arguing that the bite mark evidence used in his trial was unreliable. His request, however, was denied in 2021, with the court ruling that this evidence was not central to the prosecution's case. He then reapplied to the CCRC, which finally pursued DNA testing. The results identified a DNA profile. However, this did not match Peter Sullivan. In light of this discovery, on the 13th of November 2024, the CCRC announced that it had referred the case of the now 69-year-old Sullivan to the Court of Appeal. The police have reportedly launched a new investigation after DNA evidence that did not match Peter Sullivan was also found to have no match in the database. A Merseyside police spokesperson told The Echo in November 2024 the Criminal Cases Review Commission referred Peter Sullivan's murder conviction to the Court of Appeal following the discovery of new DNA evidence. An investigation is now underway into the 1986 murder of Diane Sindel to determine the identity of the individual linked to the DNA. As part of this effort, the investigation team has sent letters to individuals identified in the original case, requesting voluntary DNA samples for elimination purposes. No appeal date has been set, leaving another case in uncertainty. Certainty in the justice system goes beyond simply securing convictions. It requires ensuring those convictions are grounded in truth and fairness. Factors such as flawed evidence, false confessions, misconduct, bias, and evolving forensic science pose challenges to achieving certainty. While absolute certainty may be unattainable, the justice system must prioritize accuracy over finality. Its goal should not be to merely close cases, but to close them with the highest possible level of confidence. After all, justice without certainty is not justice at all. Join us again as we sit and rise in this unique trial.